Hey guys, this is John Watts. I appreciate you joining us on this live Q&A. It's been a number of years since I've done a live stream on YouTube, and they've kind of changed the process. So hopefully this is working. It seems like it is live. And what I wanted to do with this, whether this is a one-time thing or we do this once a week or once a day, just kind of depends on what you guys want. Uh, I wanted to go through some questions, and some have been submitted ahead of time, but I believe you can chat and put in a question, and I'll answer any of those that come. Or I've got about 5 or 6 that have been submitted, and I'm happy to go through those as well. So again, thanks for joining me. And what we'll cover in this is really just any type of consumer uh, issue. It could be dealing with a mortgage company, a debt collector, a credit bureau, it could be personal injury, it could be really just anything that is on your mind. Now, obviously, I can't give you legal advice because I don't know your particular situation. And I'm licensed in Alabama, so that's who I represent, folks in Alabama, or at least in Alabama courts. But I can certainly give you some general thoughts and maybe point you in the right direction. Everything we do is built on this idea of you have to know your legal rights, because if you don't know your legal rights, you don't know what action to take. But knowing your rights is not enough. You have to take action. So it's like the old illustration. If you're sitting in your car and you know exactly where to go and you don't step on the gas, well, knowledge is not enough. But if you say, well, I don't need to know where I'm going, I just know how to drive, well, you may think you're going to Los Angeles, but you're heading to the East Coast instead. So we have to have both. We have to know what to do and then take action with it. So let's see. I don't see any chats right now. So the first question I had is, this has to do with mortgages and foreclosures and things of that nature. How will servicers treat me? So traditionally, mortgage servicer, and that's the company that you actually pay the money to, they send you the statement. So that's going to be, sometimes it's a bank, but there's a lot of non-bank. So the biggest one is Nation Star, or they're also known as Mr. Cooper. Don't ask me why. I think it's dumb, but that's their name anyway. But it could be places like that, Aquin, it could be Wells Fargo, Bank of America. So these servicers traditionally have been not very nice to consumers and really treated consumers with a lot of contempt. So how will they be treating us now during this COVID-19 crisis? Well, I think for the most part, they're going to be fairly nice right now. Now, you may have to wait forever on the phone. You may have difficulties getting through to them, but I think once you can get them on the phone or communicate with them, then I think they're going to be pretty nice to you, okay, and pretty understanding. The rules are not set up where they're supposed to just, be merciless and grilling you about whether or not you really should get a forbearance, which is what most people are looking for right now. So a forbearance is where you get to skip payments. So if you're supposed to pay, April, May, June, July, August, September, maybe they say, hey, you know what, for the next 6 months, you don't have to make a payment. So that's a forbearance. I think they're going to be pretty good about doing that. Here's where it'll get challenging for consumers. And here's where I think the servicers will really kind of come to life and be not so nice to people. And that is when you get to the end of that forbearance. So when you get to the end of it, there's basically 3 options. They hold out their hand and say, give me all the money on those missed payments. So let's say you're paying $1,500 a month and you're there for let's say 6 months. Well, they're going to go, where's my $9,000? You say, well, I don't have it. They go, okay, option number 2 is we'll give you time to pay that $9,000. So you can maybe pay a half payment every month. So now you got to pay your normal payment, $1,500, plus another $750. So what would that be? $2,250. And if you can't pay that, then they'll say, well, we'll do a loan modification, or at least consider you for that. Well, that's where it's going to get challenging, because that's where traditionally these servicers have been very difficult to deal with. So you send them all this information, and then they write you a letter and say, we can't process your request for a loan modification because you didn't send any information. You're like, I sent you this whole package. And they go, no, send it again. So you send it again. And then they call you, they go, we never got it. And you go, well, I'm looking at my FedEx receipt where you guys signed for it, or certified mail, you signed for it. And they go, well, maybe we got it, but we lost it. So that's your fault. You have to say, I mean, just crazy stuff. So they'll probably be pretty nice now when you can talk to them, but be prepared in the future, and you have to protect yourself. You have to document everything. If you send them big package of stuff, have a copy of it so that when they say, well, you lost it, you go, well, here it is again. And when they say, we didn't get it the second time or the third time or the fourth time, you can keep sending it to them. So again, I think they'll be nice now, maybe not so nice in the future, and that's where we'll see a lot of violations of the law. Let's see, I got a question. Do you have any offices in Florida? I do not. Now, I know some lawyers in Florida, and so if you want to, you can reach out directly to me and say, hey, here's my situation. Here's what part of the state I live in, because I've got lawyers I work with in the Panhandle and Central Florida, Tampa, Orlando area, and then in South Florida. So if you'll let me know what you're dealing with and what part of the state you're in, then I can try to direct you to a lawyer that can help you with that. And that would be good to talk to a Florida lawyer if you live in Florida. So appreciate that question. So another question is about forbearance. And somebody was saying, basically, if I can honestly say, look, I've been affected by this shutdown, by this COVID-19 coronavirus, is there any reason I should not get a forbearance, assuming I'm qualified for it? And we'll go over this in another video, but because we'll look at the actual text of the law. But basically, the law, the CARES Act, says that if you've been affected by this, you can get a forbearance, and it has to do with federally backed loans. So these are Fannie Mae, Freddie Mac, Ginnie Mae, VA, USDA loan. So it's about 2/3 of loans, okay? And we can go through another video. I'll show you some websites where you can check and see if that's what your loan is. And so if you qualify for it, is there any reason not to take it? Well, a couple reasons. One, if you're late now, then all the months of the forbearance, they're going to report you as late. So think about, we've got these 6 months here. And this is, April. Well, if you're late in April and they give you the forbearance, then every month of that forbearance, they're going to report you as late. So maybe you want to catch it up, get it current. So then when you get the forbearance, all those months of forbearance, you're being reported as current on your credit report. Now, another thing is, and look, this is just human nature, okay? And this is also from representing people before the Great Recession, suing mortgage companies, during the Great Recession, and after the Great Recession. It's just human nature. If I don't have to make payments, there's a tendency to get used to not making payments. So if I go 6 months and I'm not paying my mortgage, then I get to the end of that 6 months, and now the mortgage company is saying, hey, we need you to pay. And I'm going, well, I'm kind of used to not paying. So you just have to know yourself. And if you have some money that you can set aside, even if it's not a full payment, set aside half a month payment or whatever you can do, because that forbearance will come to an end. And when it does, those servicers are going to be saying, hey, I want the money now. Okay, I want the regular payment, and you got to catch up all this back payment. So just if you know that, my human nature, my tendency is that if I don't have to pay something, I'm going to get used to not paying it. Well, then really strongly consider, do you need the forbearance? And if you do, try to force yourself to set aside some money. And look, we'd all like to say that we act perfectly logical. Well, we don't, okay? If we did, we would never stay up too late, never eat too many pieces of pizza or too much chips and salsa or whatever it might be, okay? So we're not just logical creatures, we're emotional creatures, and we have to recognize that. So just be careful if you do the forbearance that, there is kind of a day of reckoning, and make sure that you're ready for that. Let's see, got a question here. If I ask for the credit contract from the collection agency and they only send my account statements, is it okay to ignore them after that? So great question. So let me give you a little bit of context for the other viewers here. So you get a letter from a debt collector, and typically the first letter will be what's called the 1692G letter, sometimes called the validation letter. Say, hey, here's the original creditor, here's how much we say you owe, and then it has this sort of disclaimer on it that says you have 30 days to dispute this in writing with us, and if you do that, we will send you verification. We'll tell you the name of the original creditor, all this information. Now, look, you can dispute anytime, but within these 30 days, if you do a written dispute, then you have exercised your validation rights. So if you send in a validation type dispute letter to the debt collector, then they have a couple choices. They get that letter, they can do nothing. And a lot of people are surprised by that. They do not have to respond to you, but doing nothing means no collection. Or they can respond. So that's technically called verifying the debt. They can respond, and now once they respond, they can resume collection activity. So do nothing, respond by verifying the debt, and we'll come back to that in a second. Or they can get rid of the debt. They can just say, you know what, we're sending it back to the original creditor. Maybe they're a debt buyer. They sell it to somebody else, and they wash their hands of it. They don't have to do anything else with it. So the question comes up, well, what do they have to send you when they verify the debt? Well, a lot of that depends on what did you ask them for? What did you dispute? So here's the way I'd like you to think about it. Sometimes we just do kind of a general, generic dispute. There's nothing wrong with that. Okay? Sometimes we get a letter and we're like, I don't know who these people are. So you say, look, I dispute this. Send me any proof you've got. And that's fine. And then they just have to respond in kind of a general way. But let's say you get really, really specific and you say, look, I paid this off 6 months ago with check number 1234. Well, now they can't just respond in general and just give you a couple of statements. They've got to go check that out. Like go to the original creditor, go to previous debt collector, whoever it is, and say, hey, was this really paid? Check 1234 for $500 6 months ago. They've got to check that out. So the question is, if I ask for the contract, well, let me answer that a couple different ways. Because sometimes when people say the contract, they mean, I want the contract between me and the original creditor. Okay. Sometimes people say, well, I want the contract between the debt collector and the original creditor. That they don't have to give you. Okay. Now, what if this is a debt buyer, though? They claim to have bought the debt. Is it okay to ask for the purchase agreement between the original creditor and the debt buyer? To me, the answer is yes. You can do that because this debt buyer is saying, we now own your debt. So I'm talking about Midland Funding, Portfolio Recovery, LVMV Funding, those types of companies. They say, we own your debt now. Okay, show me the proof. Give me the purchase agreement. Now, they never will. Okay, they absolutely will not give that to you. Okay, and different judges are going to have sort of varying opinions on whether they have to, but it's something that I would ask them. Now, in terms of the contract between me and the original creditor, that's legitimate to ask for. Just keep in mind for most credit card type situations, there is no sort of signed contract. It's you filled out something online, you called in, and most states say that when they send you the credit card and you use it, you've accepted that contract. Well, what are the terms of the contract? Well, that's going to be the user agreement, user terms and conditions. It's all that kind of fine print that they'll send you. So it's okay to ask for that because you need to know, like, all right, there are late fees in here. What's the basis of those late fees? How do we know how much can be charged? Well, that's going to be in those user term and agreements. So I would ask for that. So going back to the question, if they only send my account statements, is it okay to ignore them after that? I would just follow up with another letter and say, hey, you sent me these statements. Okay, thanks. But I need the contract. I need the user term and conditions, whatever it is. And so keep in mind this whole sort of the debt validation letter and then your response and their response and your response. It's not just a one-time deal. You can go back and forth and you keep asking them and pointing stuff out. Hey, you didn't answer this question. You didn't produce this document. So hopefully that's helpful. Let me see here. Okay, so I asked for specific documents like deed of assignment, original contract with my signature. Okay, that's good. So you certainly can ask for that. Now, the original contract, I mean, they're not going to like, and I don't think you meant that, they're not literally going to send you your original contract. Okay, sometimes people say, well, the only debt that's valid is the original contract with my, blue ink signature. And I demand that they send that to you. Well, if that was truly the only thing that proved the debt, well, they're not going to send it to you because now they can't prove the debt. They can send you a copy of the original contract. Depending on the type of debt this is, you may or may not have a contract. Like I said, with credit cards, oftentimes there is no signed contract. It's just you apply it online, they send it to you, you used it. And so at least in Alabama, and I think in most states, they say that forms a valid contract. So hope that that's helpful to you there. Let's see. Chris asked, if someone has made a verbal agreement with a debt collector, is there any recourse for negotiations or validation? So, Chris, give me a little bit more information about that. Are you talking about made an agreement to pay, and then after you start paying, you decide, well, hey, I want to get some validation here of the debt? I think that that's fine. You can certainly ask for that because you may agree to something, and then give me an example. So let's say Midland Credit Management writes to me, and I call them on the phone, and I agree to pay them money because they say they have my old Chase credit card. I go, okay, I think they really own it. And look, I wouldn't just assume that, but let's just, for our example, say I think that Midland owns it, so I'm going to pay them $100 a month. And then the next month, I get a letter from Portfolio Recovery, and it says, "Hey, we have your Chase credit card for $1,000, and we own it." Well, wait a minute, they both can't own it, so that would be perfectly reasonable to reach out to Midland and to Portfolio and say, "Hey, I'm going to need some proof of this before I continue to make any payment." So that's what I would do there. Let's see. There's one here. I'm not sure. This is Mi Familia, I guess. It says even after a FO. So I don't know if that's foreclosure. So maybe you can help me understand that a little bit more. And then Betty says, I definitely need some referrals in Tampa. Thanks for all your help. Well, you're very welcome. And Betty, if you will just email me directly, and my email is John, John, at wattsherring.com. So it's WATTS, kind of like electricity, Watts. So John at wattsherring, HERRING.com. Or you can go to alabamaconsumer.com. Just fill out the contact form and let me know, what type of help you're looking for. I mean, you're dealing with a foreclosure, you've been sued by a debt collector, you got somebody blowing up your cell phone, just what's going on. Then I can hopefully point you in the right direction there. And then, okay, Marcus DeBose, that's my lawyer representing me. Well, thank you very much. Thanks for being on here for that. Appreciate that. And then, let's see, Diego says, let's say debt collectors never contacted you and filed suit. How does one find out validation afterwards? Okay, it's a great question. So a debt collector, I'll tell you this, in Alabama. Now, I think there's a different rule in Florida if we're talking about a debt buyer. I think they have to notify you before they file suit, or they have to tell you that they have purchased the debt. But in Alabama, I'll just use that because that's where I practice. They don't have to write you. They can just, boom, first time you hear of Midland Funding or AutoVest or whoever it is when they sue you, okay? Typically, you can write to the collection lawyer and ask for validation, but I would still respond to the lawsuit. Sometimes people say, well, I asked for validation, verification, and so I didn't respond to the lawsuit. Well, unfortunately, you can end up with a default judgment like that. So don't think of I have to do one or the other. Just do both. Respond to the lawsuit and send a request for validation or verification from the collection lawyer. And then typically, I'll say this. I'm not sure I've ever seen a collection lawyer refuse to do this. Kind of a challenging legal question in each case. Do they have to do this? But the safe thing for them to do is to respond. And I think most of them will respond. So let's see. Heather writes, my mortgage is not on any credit reports. I have 15 years of good payments. Okay. So a couple questions for you, Heather. First would be, who's your mortgage company? I mean, we're talking about like Wells Fargo, Bank of America, or is it a company that maybe is a much smaller company? And second, did you file bankruptcy and discharge that debt? Because once the debt is discharged, then they cannot continue to report every month on you. Okay. Now, where it gets a little confusing is sometimes we discharge the debt, but then we reaffirm, we agree to pay it again. And if we do that, sometimes they forget to then do those payments. And of course, if we're making good payments, that's really harmful to us. So I would ask, Heather, who is your mortgage company? And then you may just want to contact them and say, why are you not reporting? Okay. And find out. Now, I'll say this. There's no obligation for a credit card company, a car loan, a mortgage company, any company to credit report. The only obligation is if they credit report, they have to do that 100% accurately. So that means it's true what they're saying and it's complete. I've used this example before. Say I have a Discover card or Wells Fargo loan, whatever it is, and every January I'm late, but then all the other months I'm fine and I catch up in February. So I make kind of a double payment in February. And they only report January that I'm late. Well, is that true? Well, yeah, I'm late in January. But is it accurate to leave off all those other months? No, that's not accurate. So it has to be true and complete. So I would just ask them, are you reporting? And if not, why are you not reporting? And see what they say. So let's see here. A company called Prime Solutions told me not to pay my debts and they would invalidate all my debts. Didn't work, destroyed my 780 credit score. Can I sue them? Okay, that is a great question. So I don't know this company in particular, Prime Solutions, but this is what is a debt settlement company. Sometimes they say, we're not debt settlement, we're a debt validation company. Look, here's a better word for it. They're a debt scam company, okay? And so we're looking at suing these guys really wherever you are, because I'll work with other lawyers, particularly if you're in the state of Georgia. Just some fantastic laws in Georgia that we can use against them. But these companies will say, stop making all your payments, pay me $500 a month, $1,000 a month, $2,000 a month. And now the debt settlement people will say, we'll sort of let your money pile up. And then when everything crashes, in terms of, all your debts are charged off, maybe they've been sold, then we'll go to them and settle for pennies on the dollar. And it generally doesn't work. And these guys are violating all sorts of laws doing that. But here's the debt validation scam type companies. They say, we have this secret technique, this secret letter we can send. And we send this letter to your debt collectors, and they also send it to original creditors, even though that doesn't work. But they say, we send it to the collectors, and if they don't respond, giving us every single thing we want, then boom, we have declared that your debts are invalid and you don't owe them anymore. Well, these guys don't know what they're doing, okay? And you end up getting sued for that. So your question is, can I sue them? Well, obviously it depends on individual circumstances, but I would say if you've been paying debt settlement, debt adjustment, that's what it's called sometimes, debt validation companies, definitely get in contact with me because I am very interested in hammering those guys. Because some of these companies, we kind of look at them and say, well, maybe it's kind of a small company. Some of these companies are bringing in like 100 million, $500 million a year, and they're just absolutely ripping people off. Just, it's terrible what they're doing. So I would love to talk to you about suing these guys. So definitely get with me on that. Let's see. King Arthur asked, do you think a lot of debt buyers will go bust due to this coronavirus situation? That's a very good question. I don't think so. And I'll give you sort of my immediate experiences in Alabama. About every day, there are, on average, 100 debt buyer lawsuits filed every single day in Alabama. So some days it's 50. I've seen days where it's like 250. So they've been steady all through this process of suing. Now, is it going to be harder to get consumers to pay? Yeah, I suspect it will. So they've got a couple options here. They can either stick with the rules, stay within the confines of the FDCPA, Fair Debt Collection Practices Act, or they can say, you know what, we're going to cut some corners. We're going to get a little more aggressive. Who cares if we have to lie a little bit when we're collecting on these people, or we're going to file lawsuits that we don't really have proof on, because most people will just default and then we can garnish them. And here's the thing about judgments. That judgment sits there and it just grows and grows and grows. And then eventually your life turns around and you've got money. And now this $5,000 judgment is $20,000. Okay. So that's what they'll do. I'm sure some will go under, but not the big guys. I mean, Midland, Portfolio, Calvary, LVNV, those guys are going to be around. And they can always stop buying debt. And most of those debt buyers have very few employees. I mean, some really have no employees. They just outsource the collection of all the debt. So really their only expense is taking care of lawsuits when they get hammered for breaking the law. And then also, if they borrowed money to buy the debt, which most of them did, they've got to service that loan. So it's kind of ironic that the debt collector, may fall behind on paying their debts. But I think that they'll be in pretty good shape to survive this. Generally, debt collection, some people call it the anti-recession business. So during the recession, being a debt collector, a debt buyer is a great business to be in. They actually make more money during a recession than during good times. So they may go under, but I don't think so. Great question, though. Let's see. Dia says, thank you for yesterday's video. Received my moratorium letter. Third paragraph said they were going to send a delinquent notice to credit reporting agencies. They said their system is working on. Okay, so let's talk about that. So I'm assuming that you received this letter under the CARES Act. That's the law Trump signed that did the stimulus and the small business payroll protection program type thing, and that is what can get you the forbearance. Now there are also state laws that a lot of states have said, hey, there are no foreclosures taking place during April or May or June or whatever it may be. So if it's the CARES Act, then the question is going to be, were you current when you went into that forbearance? If you were current, they better not report you as being late. If they do, then get with me offline. I'll tell you what, let me see if I can put my email in here so it'll be easy for you. That's my email, or just alabamaconsumer.com. Get with us and say, look, here's my situation. Here's the letter I got. Here are my credit reports. Here's what's going on. Because we would want to see you dispute that, and then dispute that through the credit bureaus. And then if the credit bureaus verify that, even though the CARES Act says that you must be reported as current, assuming you were current going in, then that would be a great lawsuit against the credit bureaus and against the mortgage company. So I hope that helps. Let's see. Chris says, family member made a verbal agreement with debt collector to repay $8,000 deducted from bank account. Is it too late for validation and negotiation? Chris, I don't think so. Particularly if something has come up, and I'll give you an example. So I make a deal with the debt collector for $8,000. They're reporting on my credit report, and let's say I'm paying $500 a month, and I paid them in January, and paid them February, March, April. So that's what, $2,000, and on my credit report it says, oh, $7,500. Wait a minute, something's not right here, because they're not updating my credit report. But yet they're getting this money. Now, they probably are updating it every month, but they're not updating the balance. So if there's anything that gives you a legitimate reason to say, hey, wait a minute, I'm concerned about this, or maybe just financially I can't do it, you can say, look, I'm not going to make any more payments. I want you to validate this debt. I want you to send me proof of this, because otherwise this would be the consequence. And look, if we had a lawyer that defends debt collectors, they say that's absolutely wrong. Once you make the agreement, you're stuck. You can never get out of it. Well, let's think that through. What if you made an agreement with some scam company that's completely violating the law, and the day after you made the agreement, you realize, oh my goodness, I've been tricked by this company. They lied to me. What, you can't get out of that deal now? No, that can't be the law. That's not the law. And there's not a difference between finding out in 1 day or finding out in 10 days or finding out in 2 months. So I would definitely feel comfortable reaching out to them saying, hey, I need some proof of this. I'm a little concerned about what's going on here. Definitely check credit reports. Just sort of look at the whole picture and see if this looks right. And Chris, you can always get with me. I think you've got my email, or it's on there also. Just get with me directly. I'll be glad to chat with you. So let's see. Diego says, thanks, John. Can one send a validation letter to the original creditor to get the actual info since it's not being shown on one's credit report? So I'll say this, under the FDCPA, the Fair Debt Collection Practices Act, that is only for debt collectors, not the original creditor. So you could send a letter, but there's no obligation under that FDCPA. Now, there's a lot of states, Alabama's not one of them, but there's a lot of states that have sort of a state version of the FDCPA. So Florida, I think it's called the Florida Consumer Credit Protection Act or something like that. Texas has, I think it's the Business Code. Georgia has the, I forget the exact, Fair Business Practices Act, I think it's called. So definitely check your state. You can send that, and even if you don't have that, so let's say you're in Alabama, and can I send a validation letter to Capital One or whoever? Yes, you can do that. They may not legally be required to respond, but I'll say this, typically they will respond because they're worried that you can file a complaint with the CFPB, Consumer Financial Protection Bureau, or maybe there is a state law that applies. There's also a question of, let's say I'm in Alabama and this credit card company or mortgage company or finance company is in California. Well, do they have to follow I think it's called the Rosenthal Act in California? I'm not there, but they're in California. So most of the time they're nervous about not responding, and so they will. So I would definitely give it a shot. Anything you send that by certified mail. So let's see. Orlando, hey, how are you? Let's see. Mi familia, when having all the documentation on loans given by your lender, are you still able to sue them even after they foreclose on your home fraudulently? So, okay. So what happened is your lender committed fraud and then they foreclosed on you. So the question, as I understand it, is it too late to do anything? That's going to depend on where you are. So let's say you're in Florida. That is a judicial foreclosure state. That means to foreclose, they literally have to go to court. They have to sue you. You have to be served. They have to get a judgment winning the case, and then that allows them to foreclose. Now, Alabama is what's called a non-judicial foreclosure state. So there's no judge involved. The mortgage company says, you're in default. We're going to foreclose on you. They advertise it in a newspaper for 3 weeks. And then some guy stands outside the front entrance of the courthouse and he sort of mumbles through reading the auction, and your house is foreclosed. So it's easier, I would say it's easier in Alabama or a non-judicial state to then sue your lender for fraud, assuming statute of limitations is still good, your time period to sue. If you're in Florida or a judicial foreclosure state, and look, I don't practice in those. People bring me into federal court in other states, but I'm not in your sort of typical Florida foreclosure action. But my concern would be if your lender has sued you and you don't countersue for fraud, that you may have lost that claim. So there's some concepts, things called a compulsory counterclaim. That means you have to make the claim or you lose it. And then there's the idea of what sometimes is called res judicata or collateral estoppel, issue preclusion, claims preclusion. These are all legal words that mean, hey, look, there's a lawsuit that happened and there's a judgment, and that issue or that argument has been decided between the two parties. And so now you can't come back in another state. I'll give you an example. So Midland Funding sues me and I beat them in the lawsuit. And then they want to sue me again and say, hey, you owe the debt. I go, no, I've got this judgment. That issue's already been decided. Well, how about I sue Midland Funding and say, look, I told you when you sued me, I never owed the debt. Here's the proof. I won this case. And Midland Funding says, yes, you do owe the debt. No, that issue's already been decided in that earlier case. So that would be my concern. So I would definitely figure out, are you in a judicial state or non-judicial state? And then, you got to be really worried about statute of limitation and other issues. So I would get with the lawyer right away on that. So let's see. Miss Butterscotch says, how to get rid of a 10-year-old default judgment. Okay, so great question. And I'm going to tell you based on Alabama. Other states can be different, but this will illustrate it. So if you're in Alabama, it would be great. If you're not in Alabama, just sort of use this as a framework. So the very first thing we do with the default judgment is we say, hey, was I validly served? Okay, because if I was not served with the lawsuit, then at least in Alabama, I think in every state though, because this is really a due process type issue, if I wasn't served with that lawsuit, it would be unfair to then have a judgment against me. And so you can think about it this way. Let's say that I sue Wells Fargo. I mean, talk about a bank that has trouble staying within the law. Let's say I sue Wells Fargo. I never served them. I file a lawsuit, then I stick it in my desk drawer, and I wait 45 days, and I go, now I'm going to take a default judgment against them. Well, look, far be it from me to ever defend Wells Fargo. But look, I would have to say that would be unfair to Wells Fargo to get $1 million judgment against them. They're like, we didn't even know we were sued. So that's the very first thing. Were you properly served with the lawsuit? Because if you were not, then the whole lawsuit falls apart. Or let me say it this way. The whole judgment falls apart. Because it's kind of like this. Lawsuit's filed, then you're served, and then on top of that's the judgment. Well, if you weren't served, that goes away, the judgment goes away. Now you still have the lawsuit, okay, to deal with, but it's 10 years old. They may have trouble proving their case now. But let's assume you were properly served. Well, then you look at, is this judgment still valid? So in Alabama, it's 10 years. At the end of 10 years, it's presumed that you have paid that judgment. Now, it's pretty easy for the debt collector to what's called revive the judgment and get it extended for another 10 years. So it's a total of 20 years. And what they have to prove is you did not pay them. Because again, at 10 years, the presumption is that you paid. But if they go, no, you actually didn't pay, well, then the judge almost always will give them another 10 years. So, that thing's growing. So in terms of getting rid of it, you either attack it because you weren't served or it's become too old. Now, I think let me think for a second, it was Oklahoma. So I had a client that was sued in Oklahoma. We say she was never served. This debt buyer got a judgment against her. They come to Alabama, and you have to what's called domesticate the judgment. And then so they do that. So it sort of creates an Alabama case, and then they started garnishing her. Well, we were able to show with some Oklahoma lawyers, just some fantastic lawyers in Oklahoma, that the judgment was too old. And I want to say it was like 4 years or 5 years. And if there's no collection activity, then the judgment is like forever void or something like that. Anyway, we were able to, through our Oklahoma lawyers, to get the judge to rule that. Then we come back to Alabama and we sue this company and just beat the daylights out of them in this case because they were collecting on a void judgment. So look in your state to see, maybe is it too old? But if you're properly served, it's not too old, and you can't just live with it, then you've got to look at settling it or filing bankruptcy to get rid of it. So I would kind of go through that checklist, served, is the judgment still valid? Can I settle it? And if I can't settle it, can I talk to a bankruptcy lawyer about getting rid of that? Just one thing with the default judgment. Normally, it's not the judgment itself that's a problem. It's the lien on your property. Okay, you have to be careful when you go through bankruptcy. You might get rid of the debt, but have you gotten rid of that lien? Have you stripped that lien away? So definitely talk to your bankruptcy attorney about that. Let me see here. We've got a question, quite a few medical and hospital debt reporting on the 3 credit reporting bureaus. Do I have any rights under the HIPAA laws? So it's a great question. And let's see, Girolamo? Anyway, I'm sure I just completely butchered your name, and I'm very sorry about that. So HIPAA doesn't have what's called a private right of action. In other words, you can't say, well, somebody violated HIPAA, so I'm suing under HIPAA. But you kind of use HIPAA in a roundabout way. So we want to look on the credit reports and see what's being reported. what information is out there. It may be improper information that's being reported, and it may be a debt collector that's reporting it. So I'll say this in general, when we're dealing with hospital, medical type debt, whether it's the hospital itself, which we don't see that very often. I mean, I'm trying to think the last time I saw sort of the original creditor on a medical bill. It's almost always a debt collector. And there are some debt collectors that collect everything, and then there's some sort of specialized medical debt collection. And you want to look and see, was this properly submitted to insurance? Is the accounting right on it? I mean, these guys are terrible about getting the accounting right. We'll pay a bill and then it still goes to collection and they're reporting that. So, I frankly like suing the debt collectors for that, because I mean, I've had personal experience where a family member goes to the ER, and I mean, like 2 years later, we're getting a brand new bill. I'm like, who is this? We didn't see this doctor. Like, why are you writing me 2 years later? You've waited too long for insurance. And so everybody knows, even in the medical bill, they understand the medical billing is just chaos. Okay. So I would always check first to see, is this accurate? Did they properly submit it to insurance? Is the doctor charging you the right amount and all that? And so you can definitely ask for verification from the debt collector, go directly to them, maybe go directly to the hospital and ask them. Dispute this on the credit bureaus. And so if there's some interest in this, I'll do a video just sort of separately on medical debt. Let me make a note of this. And but anyway, that's what I would look at doing. Let's see. How long can I be sued for a debt in Georgia? This is Shady Slim. So I'm not sure. I just don't know. Typically, most states is going to be, I'd say, at least 3 years. If it's an auto loan that you got directly from the dealership, so I'm not talking about going to Wells Fargo and getting an auto loan, then going to the dealership. I'm saying you walk into a dealership and there's a contract, it's got their name on it, then they assign that loan. Typically under the UCC, Uniform Commercial Code, that is 4 years. I'm not sure if it's that way in Georgia. It's that way in Alabama. But I'm just not sure exactly what statute of limitation is. There should be one for a credit card, one for just like a normal written contract, and then one for a like a car loan type situation. So let's see. Aaron says, what about medical debt? After sending a validation letter to a collection agency, they in turn send an itemized statement without a release form. Isn't that a HIPAA violation? Yeah, so that's a good question. And that is one strategy to reach out to that debt collector and say, hey, you sent me a letter. It says I owe $514.76, from XYZ hospital. What is this? Okay. Yeah, I've been to that hospital, but I've been there a dozen times. I don't know what this is. And then really what they should do, and the smart ones will do this, they will forward your letter to the hospital and have the hospital directly contact you with the proof. And the collection agency will say, due to privacy laws, we are not responding to you directly other than to say the hospital will, and after they tell us they've responded, we will then write to you again. So that's one way to do it. But again, with the HIPAA violation, you can't sue directly under that. Now, sometimes you can take a state law, maybe what's called an unfair and deceptive acts practice type law. Like I said, in Georgia, maybe the Fair Business Practices Act. I think that's the name, FBPA. But you may have some way to kind of take a HIPAA violation and turn that into a violation under your law. So it's definitely something to look at. But like I said, the smart debt collectors that deal with medical debt, they don't want to be getting your personal medical information to send to you, because they do understand that's a big violation of HIPAA. At least as I look at it, that's a violation. So let's see, King Arthur, is it true debt buyers can never provide proof they own the debt? So I'll answer it this way. I would say no, that's not true. In other words, they can prove they bought the debt if they really bought it. Now, what I have found from defending people for, I can't even tell you, thousands of cases by debt buyers, that whether they can prove, in my experience, they will not prove. or they're unable to prove because they don't understand the way the rules of evidence work in court. And so, I'll have, this was probably a $35,000 debt buyer suit. And so I go to trial and, I'm not the plaintiff, I'm the defendant. And so the judge says to the plaintiff, okay, call your first witness. And the lawyer says, we call by affidavit Susie Smith, and she will prove that we own the debt and John's client owes the debt. And I look at the judge and say, Judge, I object. Affidavits, it's hearsay. They can't come into evidence. And the lawyer's like, but it's a sworn statement. It's an affidavit. Look, here's the notary. And the judge is just kind of up there like, oh, this is embarrassing. And he's like, you can't put an affidavit in on a $35,000 case. This is not small claims court. And most small claims judges won't let them either. So my point is, they either don't own the debt or they're incapable of proving it. Or let's say they know how to prove it. We demand that they put in the purchase agreement. Okay, so you've got Capital One and LVNV. Well, there's a contract where LVNV buys it from Capital One. That's called the purchase agreement. What they'll put in what's called the bill of sale. That's one piece of paper from the purchase agreement. So when they don't put in the purchase agreement, we say, Judge, there's no proof that they actually own it. There's just people talking about they own it, but there's no actual proof. So think about it this way. If we're in an argument over who owns a house at 123 Main Street, the judge doesn't want to hear us talking about, well, here's my Christmas card in front of the house. And you go, well, here's my Thanksgiving card in front of the house. They're like, where's the deed? The deed's the proof. We don't want to hear people talk about it. Let's show it. And that's called sometimes the best evidence rule. Okay. So if a case involves a dispute over a marriage, were these two people really married? Well, let's stop talking about it and here's the marriage certificate. Okay. So a lot of times they're just unwilling to produce those documents, and they say it's because of super confident. That's not why. Okay. Actually, you can find most of these online. The reason is generally in that purchase agreement, the original creditor says we make no representations, zero, nothing, no representations that any of the information we're selling you is remotely accurate. Now, why do they do that? Because they don't want that debt buyer coming back on them and saying, hey, these 5 accounts you sold us and turned out you had the wrong balance on there. Capital One or Chase or whoever is saying, you know what, guys? Buy it at your own risk. We're selling it to you as is. No representation. Anything's accurate. Well, now the debt buyer comes into court and they've got all these papers and they say, Judge, this is the gospel truth. Well, it's kind of hard to say that when the purchase agreement says, yeah, we make no claims any of this stuff is remotely accurate. Some of the purchase agreements tell the debt buyers you cannot sue. Obviously, they don't want to put that into evidence. So it's not true that they can never prove it. I just haven't seen them prove it. Now, they swear to me they prove it all the time. Well, they don't prove it in my cases. Maybe I'm just lucky. Okay. But so I tell you that to say you have a chance to beat them, but don't take that the wrong way and say, oh, well, they're not even going to make an effort, or, they're not even going to show up. I mean, you've got to be prepared to beat them. And the more prepared you are, the better you'll be. What's the old expression? The more you sweat and practice, the less you bleed in battle. So be prepared for that. Let's see. Marcus here, John, I've already client. We need to sue Prime Solutions. Yes, definitely do that. So you have all the contact information already. Okay. So I will get with Carolyn and Randy on that, and we'll definitely be in touch with you on that. So let's see. Dia Draper, the moratorium papers state there's 6-month moratorium, but then it states it will review me next month. Again, this is under the COVID Act. Okay, so or at least I think you're saying under the COVID Act. So that would be my question. Is this under the CARES Act that was just passed a couple of weeks ago, or is this some state law thing? Because the CARES Act talks about 6 months forbearance. Okay. Now, some servicers may call that a 6-month moratorium, but there actually is a difference. So a moratorium is saying, we're not going to allow you to do a foreclosure. Okay. And there is that in the CARES Act, but it's just for a couple months. But the forbearance is you will be treated as if you made the payment for credit reporting purposes only if you were current going into that forbearance. Now, if you're late, they're going to report you every month as being late. And you still have to make those payments ultimately. They're just saying, take a break from making those payments right now. So, and if you want to, just email me the information and I'll take a look at it. And if you're not in Alabama, I'll try to help you find somebody to help you. So let's see, Heather, thanks, Philip. Heather, okay. So you are very welcome for that, Heather. So let's see, Diego was doing good, do it yourself till I think summary judgment trick, debt collectors lied, filing it, sent by certified mail, first submission. So Rule 56 under the federal rules and Alabama Rules Civil Procedure in most states use the same sort of numbering convention. Rule 56 is summary judgment. So you're sued by a debt collector, debt buyer, and so let me just walk you through kind of in normal terms. So you're sued, you're served, you do discovery. That's where they send you interrogatories, they take deposition, whatever it is, and then you go to trial. Well, right before trial, they can file what's called a summary judgment that says to the judge, there's no reason to have a trial. We don't need to have a trial. It's undisputed that all the facts are in my favor, the debt collector's favor, and the law is in my favor. No reasonable jury or judge could rule against me. So go ahead and summarily enter judgment. We don't need a trial. Just go ahead and enter judgment. And so you have to be very careful if you get one of those because they're very dangerous. You've got to respond in the right way, at the right time, in the right format, at the right location. And a lot of times people just skip that. And then they end up getting a judgment against them. So if you get that, and obviously if you have a lawyer, your lawyer will help you with it. If you're doing it on your own, I would really recommend talking to a lawyer in your state, even if you have to pay them some money just to get some advice, because you want to know how to respond in the right way at the right time, because it's very, very dangerous for you. So that would be my thoughts there. Let's see. Diego says, oops, did receive them actually, just told the court they did not. Let me go back up here and see, because I'm not entirely sure about that. Okay, so maybe you're saying that they did receive your response and they told the court they did not. So I would definitely get with a lawyer in your area, your state, your city, whatever. Have them look at that. And because, look, I've seen the collection lawyers, whether it's by mistake, I think the good ones, it's by mistake. I've seen some that I go, I'm pretty sure that was intentional, where they maybe are pretty free with the truth and what they tell the judge. So, and the judges are aware of who tells the truth and who doesn't. So I would definitely get with the lawyer to help you with that. Aaron says, thanks for all the info. We all appreciate you taking time to answer a question. Oh, you're very welcome, Aaron. So thank you for that. And Dia says, yes, the CARES Act. So, yeah, here's the thing. Dia, get with me. And again, my email is in the chat, john@wattsherring.com. And I would like to see the letter you received and tell me whether you were current or not when you got that forbearance. Because if you were current and you got the forbearance and they're telling you they're going to report you as negative to the credit bureau, I'll say this. We knew there would be a lot of problems with this, but we assumed it would be sort of after the fact that they would go back and adjust the credit reporting. It sounds stupid, but they do that sort of stuff. And they would report you as late. I'm really surprised that a company, if you're current right now, is saying, you know what, you were current, we just granted you the forbearance and we're going to report you as late. If they do that, I'm just telling you, that's a fantastic lawsuit, okay? So you definitely need to check that out. Let's see. Ms. Butterscotch, what is a good reference for an everyday person to get these legal tips, please? Well, that's a good question. certainly we put out videos. You can go to my website, alabamaconsumer.com. We also have some on Alabama Consumer Law. What is it now? I'm drawing a blank. alabamaconsumerlawblog.com. There is a site. I think it's nclc.org, and it's the National Consumer Law Center, and they put out just incredible books. Now these are very detailed books. I mean, so the Fair Credit Reporting Act book is probably 2,000 pages. I think it's in 2 volumes. So those are really, really deep dives into everything: repossession, being sued by a debt collector, foreclosures. I mean, everything they've got. Just phenomenal resources. And it's a little bit expensive. They do have some more sort of consumer books that could be helpful, and some of their stuff is free. So I would definitely take a look at that, because that might be helpful to you. And if I didn't answer your question, just let me know. And I think okay. So Diego says, "Thanks for your time. I did respond to summary judgment. Judge accepted both as evidence to my response on that." Okay, well, that's good. If it's just the judge is ruling against you, then you need to know: can you ask the judge to reconsider? Can you file an appeal? I would just, again, kind of check out your rights on that. And if you have not yet had the hearing, so I'll tell you this: in Alabama, virtually every summary judgment motion, you have a live hearing. Okay. In federal court, at least the federal courts where I practice, it's very, very rare to have that. But under Alabama law, you're supposed to get that. So if you're not yet to that hearing, again, if you can, I would get with a consumer lawyer in your area. Say, hey, can you look at what I filed, what they filed, kind of give me some guidance? This is Judge Smith. I mean, how does she typically rule on these? What is she looking for? And I think that would be a good use of your time. And, you're going to have to pay the lawyer some money, but get somebody that practices in your area, because they can really help you with that. And let's see, I think those are I don't see any more questions. We've been going close to an hour here. Let's see, Dia was current. Okay, well, Dia, if you'll get with me, I will email you back. Have all my contact information, so you can scan the letter, with your cell phone. Mine's actually across the room here. I was going to hold it up, but iPhone, Android phone, just look for a scanning app. Just use your camera, and those take really good sort of PDF pictures, if you will. You can even use just your camera on your phone. What I would suggest is just try to make sure it's legible. I mean, people will send us stuff and it's like got this sort of weird angle and you can't read half of it. And so those scanning apps will sort of force you to, it'll say like, lay it on the table and you'll look down and it has kind of like a little square around the letter, and it'll make sure you've got a good picture of it. And then you can forward that, have my fax number on the email. You can fax it to me. So, I mean, we can figure out logistically how to get the information to me. So that's not a problem. And then Miss Butterscotch, thank you so much. Well, you're very welcome. I really appreciate others are vague, giving valuable tips, information for free, thoroughly. Well, again, thank you very much. I'll say this. I do this for a couple of reasons. One, I enjoy it. It also helps sort of keep me sharp. There's an old adage that if you really want to know something, then teach it. And so I've been teaching, in live, we call them CLEs, continuing legal education, seminars to lawyers. It might be 10 lawyers. It might be 500 lawyers in the room. And so I enjoy teaching because, when you're going to teach something, you got to make sure you actually know it. And then seeing different things, what are people experiencing? So like with Dia saying, I was current, I got this forbearance, and now they're telling me they're going to report me as late. I'm really surprised by that. Okay. But that helps me to go, okay, let me see what's going on here. So I enjoy it. I really like this better than just doing sort of a normal video because we can have some feedback. And, since we can't be in the same room, at least we can sort of virtually be in the same room. So you're very welcome. And I appreciate everybody asking questions here. And well, thank you, King Arthur. Very nice of you. And so let's do this. I've got a little bit more time, then I've got to get something filed in court. But if you've got any more questions, let me know. If you guys like this, I'm willing to do these more. And I don't really have a set time. If this was a good time for people, we can do it again. And so just either put in some comments or just reach out to me directly and say, hey, I like that, or, this would be good to do. And then I'll try to schedule these. And I'm still learning exactly how the YouTube live stream works, but hopefully this has been good for everybody. And well, we'll wrap it up now. So it's been about an hour, and like I said, just let me know, and I may just try to schedule these whenever I have time. And you can always reach out to me privately. I love the comments and all that. If you have really personal information, obviously don't put that in a comment. Just reach out to me directly. And I'll just say one thing about being in other states. So I practice in Alabama. If you're in Alabama, I certainly would be glad to talk to you directly. If you're outside of Alabama, I'll be glad to talk with you to help you find the right person. Or if you have the type of case and you're interested, we have filed lawsuits in Alabama for people all over the country. Okay. And so you can agree, or what's called consent to jurisdiction in an Alabama court. And if we're suing a company that we can sue in Alabama, so these are national companies, Midland, Equifax, Experian, NationStar, all those types of companies, we can sue them in Alabama. Nothing wrong with that. Now, they may try and convince the judge to transfer your case back to your home state. Sometimes they do that. Most of the time they don't. But if they do, we can either help you find a lawyer there, or we can work with the lawyer there. I say that that's an option for you. I always recommend that you start off, try to talk to a consumer protection lawyer in your state. But I understand sometimes either you can't find somebody, or maybe there's just not the right fit. So you certainly can reach out to us. But just understand there's kind of a few more hoops to jump through if you're in another state. Basically, we need a lawyer in your state to help us file in your state, or you need to do this in Alabama. And if you've been sued, that is not something that I get involved in other states. It's just to be blunt, usually the money is not enough to justify, having us come in, and you would need a local lawyer. And that's so local that, we don't know what the rules are there. But if I'm in federal court in New York, or federal court in Wyoming or Florida, wherever, I mean, federal court is pretty much the same all over. So hope that makes sense. And let's see, Miss Butterscotch estimate, just reach out to me and we can talk. There are some things that we do charge a consultation fee for, but usually that is not involving suing the bad guys. Okay. That's, somebody comes to us, they say, hey, I'm being levied $100,000 by the IRS. Then yeah, usually there's a consultation fee where we help somebody with that. But if you're talking about this debt collector's doing this, or I've done these disputes with the credit bureaus and they won't fix it, can I sue them? I don't charge consultation fees for that. So just get with me and I'll be glad to help you any way I can. And you guys have a great day. And assuming I figure out how to stop there's a red button that says end stream. I'm going to guess that I click that and it'll take care of it. So you guys have a great day. Thanks so much for the comments and the kind words, and I'll talk to you soon. Okay, bye-bye.